sorry. So right to freedom is what? We have 5 rights, 19, 20, 21, 22, sorry, 4 rights. So we have the first important right is Article 19, protection of 6 rights, freedom of speech and expression. That is where this press, Indian media, press and print and electronic media derive their freedom from. So nobody can touch the media because they are protected under Article 19, freedom of speech and expression. What are the 6 rights? So freedom of assembly, association, freedom of speech and expression is the first right. So I have not mentioned freedom of speech and expression here. So freedom of speech and expression is the first right. Next is, so you can speak whatever you want, you can express yourself in whatever way you want. However, there are certain restrictions. It is subject to public morality. Next comes, so as I said, the press and even your RTI holds its origin in freedom of speech and expression. Sorry. Next comes your freedom of assembly. Freedom of assembly. So you can assemble wherever you want, that is in the public places, peacefully, without any arms, without carrying any arms. Arm means machetes and other such arms, guns, so knives, all these things. If you carry such arms, you are liable for prosecution. However, when section 144, what is section 144? Curfew. So it is called as curfew in general parlance. When section 144 under CRPC, what is CRPC? Criminal Procedure Code. When was it enacted? 1973. When was CPC? Civil Procedure Code enacted? Enacted before the British left. So we are still, Civil Procedure Code is not yet amended. So Criminal Procedure Code 1973, section 144 is imposed, then you cannot peacefully assemble. Next comes freedom of association. So to right to form associations. What are the associations? Like companies, political parties, NGOs, organizations. All these can be cooperative societies. So even your cooperative societies come under this freedom of association. Next comes freedom of movement. You can travel anywhere within India. Anywhere within India you can travel, right? However, that is also subject to certain restrictions, that you cannot go to restricted areas like tribal areas. Tribal areas and all you cannot go and visit. So if you also want to visit 4 states, that is Arunachal Pradesh, Nagaland, Mizoram and Manipur, you need inner line permit, ILP, that is also there. It is in the interest of national security. Okay. Next comes your freedom of residence. You can reside anywhere you want within India. So this is the cause of origin for internal migration. So we see a lot of Bihar and Uttar Pradesh migrants and also migrants from Northeast India residing in majorly in Maharashtra, Karnataka and Punjab, Haryana, Delhi and various other parts. So wherever you say sons of soil theory, that these people do not belong to that particular state, they are constitutionally protected, that they can, Indians being an Indian, even the Northeast people can reside in any of the part of India. So they have constitutional protection of residence. Next comes your freedom of profession. You can practice any profession, however legal profession, and you have to pay taxes timely. This does not entitle you to practice illegal professions like trafficking, prostitution, and smuggling, trading in drugs, manufacturing of arms without license. All these things are prohibited. So, next comes your protection in respect of conviction for offences. Suppose someone has committed an offence, so there he has certain protection granted by Constitution. Why this Constitution has granted such protection? Because during British times, what used to happen? There used to be arbitrary convictions based on the whims and fancies of the government. So there was no checks and balance on the government. That is why this was included in the Constitution. So what does it say? No ex post facto law. Suppose you commit a crime yesterday and there is a new law today. New law is enacted today. So you cannot be prosecuted under the new law because your crime is committed yesterday. So you have to be prosecuted under the old law itself. Next comes no double jeopardy. That means suppose you are committed a crime, then you cannot be prosecuted twice. You can be prosecuted only once for one crime. Next comes no self-incrimination. That is, you cannot be forced to give evidence against yourself. So you have right to remain silent. So this does not. So this also has certain exceptions. That is, when you are convicted under certain terrorist acts, that is UPA. UPA doesn't entitle you right to remain silent. Next comes your protection of life and personal liberty. That is, whether you take, that is your Article 21. So we have Hadiya case, Maneka case, and Puttaswamy case. Right to privacy. Which case? Puttaswamy judgment by Supreme Court. What does Maneka Gandhi case say? Right to life is a fundamental right, is again justified by the court. In Maneka Gandhi case, what does Hadiya case say? So the person has right to choose a life partner on their own if they are above legal marriageable age, that is 18 years. So in the Gopalan case, so Supreme Court, Gopalan case, 1950, Supreme Court had taken a narrow view. Narrow view means, so right to life is available only against arbitrary executive action. Executive action means government cannot arbitrarily take away someone's life. You cannot do encounters. However, it is not applicable to arbitrary legislative action. However, by passing a law, government can take away someone's life. However, in case 1, Maneka Gandhi case said, no, it is available against both arbitrary legislative and executive actions. So earlier what used to happen, what was the terminology? Earlier we used to follow procedure established by law. Procedure established by law means, so arbitrary legislative action was allowed. So if legislative action allows encountering a criminal, then encountering can be done. However, post Maneka Gandhi case 1978, it is said that you cannot take away the right to life even by arbitrary legislative action. So that action should be justifiable. So the court has introduced procedure established by, due process of law. So due process of law means the law should be justifiable, reasonable. So earlier we used to follow Japanese model, that is procedure established by law was followed in Japan. However, due process of law is followed in USA. That is why United States of American Supreme Courts are, federal courts or the state courts are the one of the most powerful courts in the world. Okay. Next comes your right to education. Does it have a specific right? So let us first discuss certain right provisions under right to life. What are the provisions under right to life? Right to live with human dignity, right to sleep, right to remain silent, right to free legal aid, right to food, right to information. So your right to information also has origin here. Right to health, your Ayushman Bharat, right to privacy, right to livelihood, your Manrega, right to sleep, right to opportunity, so many other rights. This also forms a part of basic structure of the Constitution. So you can type your doubts, whatever you have, in the comment section. We will try to address it. Okay. Next comes right to education. Was it there in the original Constitution? No. Does it have a separate article for it? Partially, yes. That is Article 21A. It is under right to life only, but under a subsection A. So, right to education means what? So, earlier, so this was introduced when? During the year, right to education was introduced during the year 2002 by constitutional amendment. So, right to education says every person until the age of, from the age of 6 until the age of 14 has the right to access free and quality education. So 6 to 14 years is the time limit. They have to get free and quality education from the government. That is why this Sarva Shikshan Abhiyan, Samagra Shikshan Abhiyan. So that is why this midday meal scheme. So all this start from right to education. Even your 25% reservation in the RT Act. When does the RT Act was enacted? 2009. 25% reservation for sorry, 25% reservation in the private schools for weaker sections was enacted. So it comes under right to education. Okay. Next is your protection against arrest and detention. So we have Indian Constitution is one of the few constitutions which has made preventive detention. Preventive detention means what? So there are two kinds of detention. One is punitive detention, another is preventive detention. Punitive detention means you are detained, you are arrested only after you commit a crime. Once you commit a crime, then only you are arrested. However, preventive detention means you are prohibited from committing a crime. So all this Public Safety Act in Jammu and Kashmir, National Security Act, everything allows preventive detention for people who are over enthusiastic to cause disorder in the public, in the society. So they are arrested. So it has got two parts. The first part is right to protection against arbitrary detention against ordinary law. Under such law, you are entitled to be informed of the grounds of detention. So the police have to inform you why you are detained, and within 24 hours, if you are not produced before the magistrate, then you have to be released immediately, and you are entitled to be represented by a legal practitioner, that is a lawyer. Right to free legal aid. Free legal aid comes under Directive Principles of State Policy, Article 39A. Okay. Next comes in the case of preventive detention, by preventive detention laws, certain laws, as I said, UPA 1967 to prosecute terrorists. In such cases, the prevention cannot exceed 3 months. It cannot exceed 3 months. However, a board, expert board has to recommend further detention. This expert board, advisory board, is constituted by the judges. So judges have to allow your detention post 3 months, or else you have to be released. In this case also, you are entitled to be informed of the reason for detention, except in case of national security. Okay. So right to freedom is done. Moving further, we have right against exploitation, Article 23 and 24. So right against exploitation. What does this right against exploitation do? What does this right against exploitation do? So, first of all, it prohibits traffic in human beings and forced labor. What is human trafficking? This prostitution, selling of human organs, forced labor, beggar. What is forced labor? Earlier you used to have vishti and beggar, which are forms of forced labor. You take a debt from a local moneylender or zamindar, you don't repay the debt, you are forced into a labor for generations together. So, beggar. So, right against such forced labor is under Article 23, and also human being trafficking. So, international trafficking, domestic trafficking for prostitution and any other things. So, it also prohibits things like Devadasi system and also slavery. Slavery was made illegal in the 19th century, until which it was legal. Next comes your, so here under Article 23, we have under the provision of Article 23, various acts have been enacted. What are the acts? Minimum Wages Act, Bonded Labor Abolition Act, and various other acts have been enacted. Next we have prohibition of employment of children in factories. Children are protected from employment in factories. So, under what age? So, within 14 years, all children are prohibited from working except in family-based enterprise. However, from 14 to 18 years, only hazardous work is prohibited. Other employment is not prohibited. What is the law that enables this provision? So recently the government in 2016 enacted the Child Labour Prohibition and Regulation Act. Okay. That is the major act. So the years are important here. 14 years is the benchmark, and also 18 years, post which you will be an adult. So who is the person who has done a revolution with respect to protection of children rights, saving children from labor, child labor? It is Sri Kailash Satyarthi, who was awarded Nobel Prize. Okay, next comes your right to freedom of religion. So, what is one of the most important right in context of India, which gives force to the secularism provision of the what? Secular provision of the preamble. Okay. So, freedom of conscience and free profession, practice and propagation of religion. So, freedom of conscience. Conscience means what? So, you are allowed to decide for yourself what is good for you. You can think for yourself. You can freely profess whatever religion you want, and you can freely practice that religion without any threat, and you can propagate that religion. You can conduct seminars and programs to propagate that religion. However, it does have certain caveats. What are the caveats? So it doesn't involve right to convert. So the present issue is anti-conversion bill being debated in Uttar Pradesh and various other states. So this propagation of religion doesn't entitle you to right to forcefully convert someone into your religion by advancing economic benefits or any other benefit. Okay. Next comes your right to manage religious affairs. Here comes the issue of Sabrimala and Haji Ali Dargah. So what does it say? You can manage your own religious affairs. That means you can establish institutions to manage religious affairs. You can own immovable or movable property in the name of religious institutions. So you can administer it according to your own religious laws, and these are the provisions under freedom to manage religious affairs. So here comes the issue of Sabrimala. So you can manage your own religious affairs, which entitles the religious organizations to prohibit women from accessing temple sanctum of Sabrimala. So Young Lawyers Association of Kerala filed a case in Supreme Court, and Supreme Court legally made it invalid to prohibit women from accessing sanctum of Sabrimala. So here comes the issue of ERP, essential religious practice. Where can you trace this origin to? Where did it evolve? Essential religious practice. Essential religious practice means what? Practices which are essential to a religion. Like, for example, performing namaz 5 times a day is essential for the religion of Islam. Likewise, Hinduism also has certain essential religious practice. The court questioned whether prohibiting women is an essential religious practice. So they took reference from Shirur Mutt case, 1952. From there, they took the reference and said that no, it is not an essential religious practice. Similarly, not allowing women to inside the Haji Ali Dargah was also said in void in the respect of constitutional equality, and said no, it is not a essential religious practice. Okay. Next comes your freedom from taxation for promotion of religion. So this is where all the black money in the religious institutions find its origin. So religious institutions need not pay any tax. They are exempt from paying any tax. However, they can be charged some fees for managing of some secular affairs, like conducting Vaishno Devi Yatra. So the government can charge certain fees to ensure security of the travelers. However, they cannot be taxed for that, carrying out that yatra. So earlier, during the Delhi Sultanate, there used to be jizya tax on Hindus to practice their own religion. So now that is not there. So next comes freedom from attending religious instruction. Article, which article? Article 28. So this in certain institutions, the children cannot be forced to attend religious instruction. So, for example, earlier what used to happen before the independence, these Christian convents and missionary schools were forcing children to pray to their particular God against the provision of the child's religion. So, without the permission of their parents. Now, constitutionally, you are allowed freedom from attending such religious instruction. So, where all this is allowed? So, institutions wholly maintained by the state. So, state government, that is government school, you cannot give religious instruction. So, religious instruction cannot be given in government school. Institutions administered by the state but established under any endowment or trust, there administered by the state, there actually religious instruction is permitted. However, in the case of institutions recognized by state, institutions receiving aid by the state, so certain colleges, aided schools and colleges, so aided and institutions recognized by state, their religious instruction is permitted. However, the child's parents, or if he is an adult, or if he or she is adult, his or her consent is necessary to attend. Okay, this is all about freedom of religion. Next we move to cultural and educational rights. Article 29 and 30. Protection of interest of minorities. So, all the communal chaos which was there pre-independence. So, when did communalism start in India? Is it a historical fact or a creation of British? So, it is said that since ancient times, since the arrival of Islam in India, the communal incidents were not so stark. So, though it was there, it was not so stark. However, only after the 1857 War of Independence, so then the British started using Muslims as baits. So, they used them against Hindus to promote their own interest, which resulted in spread of communalism, which ended in the division of India into India and Pakistan, right? Okay. So, protection of interest of minorities. So, post-independence, it was said that there was lot of threat for minorities. So, minorities includes Christians, Sikhs, Jains, Muslims, Parsis and other sects. Okay. So, what does it say? Protection of interest of minorities. So Article 19 provides that any section of citizens residing in any part of India, having a distinct language, script. So it also includes linguistic minorities, not only religious minorities, and cultural minorities also. What are the cultural minorities? These transgenders are a cultural minority, and also, they are a social minority actually. So even they form a section of minority. Even people with disability are a minority section. So people having distinct language, linguistic minority, script, tribals have their own script, and also culture of their own, have the right to conserve the same. So they have the right to protect the same. So coming to the next right. So this is all about your protection of interest of minorities, that is based on language, script and culture. Okay. Moving to right right of minorities to establish and administer educational institutions. So Syrian church case, Syrian college case has its link to right of minorities to establish and administer educational institutions. So minority institutions can acquire land to administer, acquire land to establish their educational institutions, and they can hire their own faculty. That is also allowed. However, recently the Supreme Court has said that in order to maintain the quality, of education, the state government, the state can prescribe certain curriculum. Curriculum can be prescribed by the state in order to maintain quality of education in the minority education institutions. The case which I mentioned was specifically Malankara Syrian Catholic College. So Syrian College, I said you can simply write Syrian College because it's a big name to remember. So certain minority institutions seek recognition, certain seek funds. However, certain institutions neither seek recognition nor funds. So there are three categories of minority institutions which are protected under this act. So